good day, everyone. So my name is Nurin Atika binti Muhammad Naif Murani, and I'll be presenting regarding my legal research topic, which is proposing child court, protecting child witness and juvenile delinquency from psychology and safety study, taken study from United States. And my lecturer and my supervisor for this research is Ms. Nur Suziliana binti Idris. Here, as for the overview, we will be discussing regarding abstract, introduction, problem statement, research objective, research question, scope of research, significance of research, research methodology, literature review, limitation of research of the research, chapter 2, chapter 3, recommendation, and conclusion. So as for the extract, this research examines the importance of children's court in safeguard minors' rights and well-being. It examines how children perceive court process and decision that impact on their well-being and psychology and safety of child witness and juvenile delinquency. This research focuses on identifying the impact that the public or media has towards the child's mental health and during safety after the court process. So in the light of this, the child must be given transparency, communication, and opportunity to express their view during the court proceeding. The purpose of child court as protection of the child witness and juvenile delinquency is also highlighted in this study. This helps to form a child-friendly surrounding and the justice system in order to improvise the legal proceeding. So as for the introduction, the Malaysian court is structured with hierarchy of court, with the magistrate court handling the less serious criminal and civil cases, the civil court handling more substantial criminal cases, and the federal court handling criminal appeals. So, however, in Malaysia, there is no specific court for child witness and juvenile delinquency. The UN Convention on the Rights of Child and the Evidence Act of 2006 define children as young people under 18 years old. So, over 100,000 children appear in court annually. But study shows that children who testify to sexual abuse experience tension, distress, and emotional collapse. Research has shown that regular testimony is linked to worse mental health outcome, while testimony on serious abuse is linked to greater trauma-related issues. Creating a distinct court for children involved in witnessing or juvenile delinquency could resolve this problem and make the court process more smooth for the child. So as for the problem statement, so the first problem is juvenile offenders and child witness face challenges in judicial process requiring protection, health, and accuracy. However, public exposure can lead to less seriousness. And second problem is about the modern technologies make it harder to hide identities, especially for the child witnesses and juvenile delinquency. Operator error can occur when equipment is accidentally dropped or the children accidentally switch off the record device. So as for the research objective, so the first objective is to identify the impact that the public or media has caused towards the child's mental health and safety. So second objective is to analyze the effectiveness of the court as protection for the child witness and juvenile delinquency in United States. And third objective is to determine child court as protection of the child witness and juvenile delinquency in Malaysia. And the research questions is, what is the impact that the public or media has caused towards the child witness and juvenile delinquency mental health and safety? And the second question is, what is the effectiveness of the United States child court in protecting child witnesses and juvenile delinquency? And finally, the question will be, how can Malaysia protecting child witnesses and juvenile delinquency in court proceeding? So the scope of research, a children's court could potentially improve juvenile delinquency and children witnesses by ensuring they are protected from this stressing experience of testifying alongside with the adult offenders. Child courts prioritize rehabilitation over punishment, providing a safe environment for juvenile offender to testify without stress or anxiety, offering specialized treatment like mental health, counseling, and education. The goal of this rehabilitation focus approach is to help people behave well and reintegrate into society. Child court provide a disciplined and encouraging environment for young offenders, prioritizing their potential for success and overall well-being, and together with protecting the child witness in the specific child court. So the signification of research is, first one, the purpose is to provide society with improved awareness and information regarding the importance of protecting child witnesses and juvenile delinquency psychologically and safely. And the importance is to emphasize the significance of reducing children's trauma during the process. And the court structure will be child-friendly environmental in court to reduce the child trauma and safety during the court process. So as for this research, the research methodology will be doctrinal. This is to aims to collect, arrange, and explain the law, offers an analysis of the sources consulted and explain the overarching theme or system and connections between many legal sources. Also, I was able to use books, articles, statutes, and case studies for my research as reference. Literature review. So I have a few here as for my reference that I stated here. So first one is the law protecting child witness in giving evidence harmonization between Malaysian law and Sharia, sorry, writer by Muhammad Ismail. And in this article, it highlights the validity of child witness in both Sharia and civil law. Also, it discussed on the child flexibility to give sworn and unsworn evidence. And next, the title will be The Child Witness in the Courtroom by Robert Pentel. And here it emphasizes protecting child victims and witnesses of violence. Solution includes providing psychological support and potentially adding separate court to help children feel fearless and contribute freely. Next, technology in the courtroom, challenges with presenting children evidence by Anna Kretowick. This article issued about the technology usage based on few professionals' experience. And lastly, understanding children's court, processes and decisions, perception of child and their families by Brennick. This article focuses on providing the knowledge of court process and decision to the families and the children. So limitation of research. So the first limitation will be controlling time while balancing a variety of responsibility and duties, such as finishing assignments for other classes, putting together a thesis proposal, and getting ready for a midterm test all in one time. So the second limitation would be limited access to current and relevant resources, such as certain journals, papers, or legal documentation because of subscription, restriction, as well as lack of previous research study and materials on the selected issues. And lastly, would be difficulties in experiencing the study problem clearly and gathering precise data prevent misconceptions. The title is to identify the impact that the public or media has caused towards the child witnesses and juvenile delinquency, mental health, and safety. So the first point is impacts on child witnesses' mental health. Here, I discuss on during the proceeding in court. Next, I discuss on impacts on juvenile delinquency, mental health. And we have seen that the mass media, from advertising, the commercials to programming, may significantly impact our society evolution. For further information, the media coverage regarding any offences involving the child crime is often leads to misinformation. A study states that juvenile delinquency and violence are often treated as epidemic by the news media. This is not supported by the facts. This media firestorm has either created or reinforced a public impression that juvenile crime is rampant and a major threat to the safety of the community, and slight increases in juvenile crime have been blown out of proportion, while reduction in juvenile violence have frequently gone unreported. And lastly is the impact on the child witnesses and juvenile delinquency safety. So these children may be identified as a result of public exposure, which leave them open up to intimidation, stigma, and threats for anyone connected to the case or to the community at large. Because individuals are compelled to relive their tragedy through public serenity, this exposure can worsen their emotional distress and increase their risk of developing PTSD, anxiety, and depression. Moving on to chapter 3, which is to determine the Malaysian child court as protection of the child witness and juvenile delinquency. The first point is court system for child witness itself. In Evidence Act of Child Witness 2007, next point, child court system for juvenile delinquency. So in child court in Malaysia, it functions to hear and determine any charges against a child under 18 years old. Juveniles between the age of 14 and 21 are detained by the Malaysian Prison Department either as minor prisoners or as child at Henry Gurney School. The court for children in Malaysia has the same generous power as a magistrate court and is presided over by a magistrate and 2 court advisor, one of whom must be a woman, who provide advice and orders, if necessary, to the children's parents or guardians. However, Children charged with serious crime as murder, terrorism offences, hostage taking, waging war, mutiny, kidnapping, gang robbery with murder, will be tried by the High Court. So, Court for Children conducted the proceeding in a regular courtroom in the same building as the adult offences. It's strictly closed to the public and only allows the interested parties to be inside in the courtroom. Due to the limitation of infrastructure, there is only one way for the entrance to the courtroom. Also, the child on the remand has to share the same transportation to the court together with the adult offender because of lack of police vehicles and personnel. Thus, the magistrate court in some jurisdiction, the magistrate try to reduce formality and sit on the same level as the child. So overall in this chapter, uh, again that the Malaysia Child Court ensures a child-friendly legal system by safeguarding the rights and welfare of young offenders and witnesses. It strives to reduce the trauma related to court cases by providing special court sitting for the child, using high technologies such as setting video or tape recording or allowing their parents to accompany them. When handling matters involving kids, the court use specific protocols and emphasize rehabilitation and reintegration above punishment. This strategy protects children's mental health and ensure their safety during the legal processes by separating them from the damaging effects of media exposure and public scrutiny. However, Malaysia can implement ideas from other countries' strategies, such as United States, to improve in protecting child witness and juvenile delinquency in Malaysia. The next chapter, to analyze the effectiveness of child court as protection for child witnesses and juvenile delinquency in the United States. As for the United States, to protect the child that involved in legal proceeding, they ensure a speedy trial, extending the statute of limitation until the age of 25. Based on the research regarding child witnesses, child in the United States seems very comfortable in giving evidence during court proceeding. This is because the child is testifying via CCTV and this makes them not afraid to speak out and less stressed. Not only that, the United States use multidisciplinary initiative to protect the child witnesses during and after proceeding. Professionals from a variety of backgrounds, such as prosecutors, law enforcement officers, mental health specialists, and child protective services staff from multidisciplinary teams. This country has also well-trained professional who handles the child during examination. Moving on to the next point, the court system for juvenile delinquency in United States. The objective of the juvenile court system in United States was to rehabilitate young criminals. Juvenile received treatment that was significantly different from the adult offences. Juveniles were imprisoned away from the adults, records were kept private, and juvenile courts were informal and closed to the public. Moreover, this court supports parents and guardians by helping children develop into responsible adults, emphasizing the consequences of their actions to teach responsibility rather than solely punishing. By the US Supreme Court, children in juvenile proceedings are entitled to legal representation. A minor has the right to have the attorney chosen by the state represent them if they are unable to pay for one. American Council of Chief Defendant and National Juvenile Defender Center set some core principles to provide the best quality of delinquency representation. So to conclude this chapter, specialized process that protect the welfare and legal rights of the child first define the efficiency of the child courts in United States as a safeguard for juvenile offenders and child witnesses. So in the recommendation chapter will be under chapter 5. So the key strategies is for specialized court for child. Key strategy will be specialized court for children with multidisciplinary teams. This is inspired by the United States Child Court. So cases involving child victims tend to involve multiple agencies and professionals from various disciplines. One key tactic in this specialized court is utilizing multidisciplinary teams comprising experts from various sectors like law enforcement, mental health, social services, and legal advocacy. Together, these teams ensure that the child witnesses receive complete assistance during the court proceeding. In such cases, both the professional and the child victim benefits from effective communication and collaboration. So child witness and victim, particularly those affected by abuse, require a holistic approach to ensure their safety. So multidisciplinary teams assesses physically, emotionally, psychologically, and environmental aspect of the child well-being. They evaluate the caregiver's capacity to provide adequate care, identify threats, develop safety plans, and consider long-term safety consideration. So, yeah. Moving on to the next point, which is child-friendly environment court. So here, a separate court with a child-friendly environmental will be the best solution to overcome the stress and trauma faced by the child witness. As such, a study stated that the comfort and experience of children attending court can be greatly improved by having separate waiting area and child-friendly surroundings. A designated waiting area at Los Angeles County uh, Edelman Children's Court is manned by qualified staff and furnished with gaming tables, computers, readings book, and outdoor play areas. Frequent emotion supports dogs are available to offer extra comfort, thus giving kids drinks, and snacks, and small gifts like toys, teddy bears, or books can also help make their court trips less stressful and more enjoyable. The next point is specialized court for children with trained staff. This is because such lawyers can help reduce trauma and tensions in court by simplifying the hearing process and fostering trust. They can help the child understand the case, prepare for the hearing, and participate. The lawyer can also address the child's concerns about services, placement, and visitations schedule. This helps the child feel secure and supported in the courtroom. Next point will be technology testimonies for minimizing re-traumatizing. So, in the Evidence of Child Witness Act 2007 allows child witnesses to provide testimony via video or tape recording, creating a more comfortable settings for the child. According to Section 6, Clause 1 of the Act, these video recordings are admissible as evidence of examination in chief, subject to the provision of the Evidence Act 1950. And Section 6, Clause 6 stimulates that the video evidence should be treated as if we were given directly to oral testimony during the examination in chief. However, research says that the experience of giving evidence via video link from cell-like rooms distant from the court may not be the best way for their evidence. For instance, the family court would probably have to borrow video connection equipment from a criminal court and utilize court funds to pay for the services of an intermediary since there are just not enough resources in place. In addition, if technology fails, it will lead to trial delays and the complainants will become more pressed and stressed. A report by Victorian Law Reform Commission found that despite legislative provision for the use of CCTV, child witnesses were more often required to give their evidence in person anyway. Children giving evidence of sexual offences in criminal proceeding, special measures in Australia states and territories, Journal of Judicial Administration. In this case, anyhow, the children witness and juvenile delinquency still have to attend the court to the trial process, and it is better if it can be done in separate court. And the last point is dedicated juvenile court. Establish separate court to handle challenges involving juvenile and address their particular requirements within the legal system. Having a separate court ensures that the structure, rules, and operation meets a positive outcome for the juvenile offenders' future and safety. The National Juvenile Defender Centers NJDC, the National Council of Juvenile and Family Court Judges NCJC, and Fair and Just Prosecution issued a joint statement stressing the necessity of experience, training, and specialty for the judge, prosecutors, and defenders involved in the crucial practice of juvenile delinquency. This is because judges in juvenile court are in exclusive position to manage community safety, public opinion, media attention, political pressure, and a dedication to data-driven decision-making and research-based method. The judge in separate court is different from other common judge court. As for the juvenile delinquency, cases that will be conducted in separate court, the judge have their criteria that they must fill. As such, based on the study, there is a need for the judge to have prior work experience with the youth and family for the judge to handle delinquent cases in general, or more specifically, to be eligible for election or appointed to a juvenile or family court position, regardless of whether they were appointed to elected. Key strategy would be, especially to conclude this case, these strategies are inspired by the United States guidelines in handling child witness and juvenile delinquency, mental health and safety during and after legal proceedings. This clearly shows that the child court system in the United States is effective, and Malaysia should improve their child court system by adjusting the United States and child legal proceeding in the first ever separate building child court in the world that only handles child witnesses and juvenile delinquency. So in conclusion, while recent efforts in Malaysia have been begun to address the protection needed for the child witnesses and juvenile delinquents, there remains significant works to be done by establishing a specialized child court, providing targeted training for legal professionals, implementing child-friendly practices, enforcing media guidelines, offering robust support services, raising community awareness, pursuing policy reforms, and fostering integracy collaboration. Malaysia can create a legal system that truly prioritizes the mental health and safety of its youngest and most vulnerable participants. These are the references that I use for my research study. And that's all from me.